It can't simply be, well, there was an unlawful protest, and therefore let's just, we'll speculate and say that they were the cause of that. They have to be connected to this common unlawful purpose.
Well, it's certainly interesting the way that the Crown is framing their case at different points in time. Where that gets them, I don't know. I mean, ultimately, it'll be for the judge to determine whether or not, at the very end of the case, it'll be for her to conclude whether or not the Crown has proven beyond a reasonable doubt that what happened here was unlawful.
Robert Krajcik for Rebel News here in Ottawa, Ontario, reporting at the conclusion of Day 30 of the trial of Tamara Lich and Chris Barber. They're both being charged with crimes associated with their roles as organizers of the 2022 Freedom Convoy. A peaceful demonstration, by the way, that word is very important. We'll get to that in a moment related to today's proceedings. Here in downtown Ottawa, that was broadly opposed to what I frequently label the COVID-19 enterprise, a series of edicts, decrees, mandates, lockdowns, ordered by all levels of government. Now, the day's proceedings were primarily consumed with an ongoing dispute between the Crown and defense teams over a Carter application. Please check the previous 2 days of video reports, days 28 and 29, to get an explanation as to what that is, although we may go over that slightly today. The big news from today's proceedings is that the Crown, both of the prosecutors, acknowledged that the Freedom Convoy was a nonviolent demonstration. Both said that they had never even suggested that the Freedom Convoy was violent. Yet, in the opening statement on day one, we heard Tim Radcliffe state that the Freedom Convoy was, quote, anything but peaceful. So there is a contradiction from the Crown in its characterization of this protest between today and day one. Now, we were fortunate enough to speak with Eric Granger, co-counsel for Tamara Lich, and also Diane Magus, lead counsel for Chris Barber. Also fortunate enough to speak with Adam, a lawyer with the Democracy Fund, who will share some of his insights with us. But before we get to that, I want to remind you folks out there that we need your financial support to continue producing these in-the-field reports. So please help us out and visit tamaratrial.com and stay up to date with our ongoing reports. I'm going to share some quotes from the two prosecutors that took place during today's proceedings. Now, Siobhan Wester, she said that the absence of violence is merely a lack of an aggravating factor. She's implicitly acknowledging that the Freedom Convoy was nonviolent. She also said, quote, the Crown has never suggested the Freedom Convoy was violent. It didn't descend into rioting. She also said, we're not saying it was violent. Now, here's a quote from Tim Radcliffe. A peaceful protest does not necessarily equate with lawful. Why is this important? Why are these prosecutors making this delineation between peaceful and lawful? It's because they've submitted this Carter application, which, if approved, would allow for incriminating evidence against one co-defendant to be used against the other and vice versa. And in order for that application to be accepted, they need to demonstrate that there was an unlawful end, a conspiracy towards commission of some crime. In this case, a conspiracy between Tamara Lich and Chris Barber to execute and further an unlawful protest. This is why they want to emphasize that peaceful does not necessarily mean lawful, and they want the judge to side with them to interpret or characterize or view this demonstration as broadly unlawful in order to allow for this application to proceed. Now, just broadly, the purpose of a Carter application is to apply this sort of conspiratorial framework in the context of a trial in which you've got more than one defendant, so that any act of criminality attached to one defendant is attached to all the others, because they're all seen as in on it and working together in the context of an agreement in furtherance of some sort of criminal act or acts.
This sort of application is usually decided, or the law from Carter requires it to be decided on its merits at the very end of the case, in the case of a jury trial, by the jury, in the case of a judge-alone trial, by the judge. What's different in this case, and what we're doing here, is we're saying that they haven't called any evidence that would enable the judge in this case, or if it were a jury in this case, the jury, to decide this application in favor of the Crown. That's what's unusual in this case, is you don't usually go arguing that there's a co-conspirator hearsay issue if you don't have any evidence of a conspiracy. And that's what we're saying here, is you haven't led any evidence of a conspiracy, so you don't get in the door to even argue that at the end of the case, and that's what we're trying to deal with now.
It is typical to have Carter application at the end of the trial. It's not for the purpose of the Crown revising their position.
Okay.
It's for the purpose so that the judge can look at all of the evidence.
And in order to make it a conspiracy, there's got to be a common unlawful purpose. So if, like you said, the Crown is able to establish that the protest at large was unlawful, that's not enough. They would also need to connect the dots between Tamara and Chris and show that they engaged in a common unlawful purpose with common unlawful intent to have the production of this unlawful protest the end result.
Now, procedurally, let's say the judge rejects the defense team's requests to have this Carter application dismissed out of hand, and let's say she wants to have it aired out. What does that look like? Does that amount to a series of oral arguments where both the defense teams and the prosecution lay their case for why a Carter application should be accepted or rejected? Do we sort of relitigate this, so to speak, again?
Yeah, so it basically means that if she doesn't deal with this issue in our favor now, when we get to the very end of the case where the Crown is arguing that they're guilty of these offenses, we're arguing they're not guilty of these offenses, part of that argument will include going through this whole exercise again, where we say part of the reason why they're not guilty of these offenses is because none of this hearsay is admissible. And at that stage, instead of doing what we're doing now, which is saying there's no pathway to admissibility here, so you can't even consider it, she actually considers on the merits whether or not they have in fact proven a conspiracy, whether or not they've proven in fact that either of these two were part of a conspiracy. So that's what she would then do at the end of the case, and of course we are all equally still at liberty to argue at that point if she says, I'll consider Carter. Even if somehow this all gets in at the end of the day, we're still at liberty to argue that that still doesn't prove that either of these two committed any crimes.
It can't simply be, well, there was an unlawful protest and therefore let's just, we'll speculate and say that they were the cause of that. They have to be connected to this common unlawful purpose.
So to put in layperson's terms for our dear audience out there, basically, even if the judge determines that this Freedom Convoy protest was unlawful, the prosecution still must prove that Tamara Lich and Chris Barber conspired to execute and organize and further this unlawful protest, right?
That's right. And like you pointed out, it's not just that they conspired, but also that they furthered it. They worked in furtherance of this conspiracy, of this unlawful purpose. So they would have to be working in tandem and also in the future. And Granger pointed this out as well. It can't be a past tense narrative. It has to be, this is something we are going to do in the future.
This statement from Siobhan Westshire that I interpreted as sort of inversion or request to invert the presumption of innocence. Maybe I misunderstood that. Did she ask for the judge to receive an application from the defense teams to determine whether or not the demonstrations were lawful or unlawful in order to proceed with any decision that she might render over these applications? It seemed like she wanted the judge to decide lawful or unlawful before going forward. Did I misunderstand that?
It wasn't entirely clear to me, but she seemed to be raising the issue of that because we were suggesting that the rights that were being engaged here are protected by the Charter, that somehow there was an onus on us to bring an application alleging there was a breach of the Charter rights. Okay. You'll recall yesterday I was taking the judge through, may not recall because there's been a lot said the last few days, but one of the things I did was took the judge through the various crimes that the Crown has claimed that there was an agreement or a conspiracy to commit, and the various elements of those crimes, including things like mischief, this interfering with people's use of property, the streets, and so on and so forth. There's a specific defense in the criminal code saying, and I'm paraphrasing, but it effectively says that if all you're doing is communicating information, that's not mischief. So, well, undoubtedly, the folks who drafted the criminal code were influenced by the Charter right to freedom of expression when they put that in the criminal code. The fact is, it's right in there. We don't need to separately bring an application alleging that their charter rights were breached in order to say it isn't a crime if all you're doing is interfering with somebody's use of property by way of communicating.
Dear Rebel News audience, we depend on your financial support to continue producing these sorts of reports that you can't get anywhere else. So please help us out at tamaratrial.com and also visit there to stay up to date with our ongoing coverage.